Headnote A. Divorce. Ground of irretrievable breakdown of marriage. Scope and ambit of power and jurisdiction of Supreme Court under Article 142(1) of the Constitution. Grant of divorce by Supreme Court is not a matter of right, but a discretion, to be exercised with great care and caution, keeping in mind several factors ensuring that complete justice is done to both parties. Court can depart from the procedure as well as the substantive laws, as long as the decision is exercised based on considerations of fundamental general and specific public policy. While deciding whether to exercise discretion, court must consider the substantive provisions as enacted and not ignore the same. Supreme Court acts as a problem solver by balancing out equities between the conflicting claims. This power is to be exercised in a cause or matter. Headnote B. Writ. Maintainability. Divorce on the ground of irretrievable breakdown of marriage. A party cannot file a writ petition under Article 32 of the Constitution of India and seek relief of dissolution of marriage directly from Supreme Court. Headnote C. Divorce. Ground of irretrievable breakdown of marriage. Supreme Court, while hearing a transfer petition, or in any other proceedings, can exercise power under Article 142(1) in view of the settlement between the parties, and grant a decree of divorce by mutual consent dispensing with the period and the procedure prescribed under Section 13B of the Hindu Marriage Act, and also quash and dispose of other connected proceedings and orders, including criminal proceedings. Headnote D. Divorce. Ground of irretrievable breakdown of marriage. Other spouse opposing the prayer. Supreme Court can grant divorce in exercise of power under Article 142(1). This discretionary power is to be exercised to do complete justice to the parties, wherein court is satisfied that the facts established show that the marriage has completely failed and there is no possibility that the parties will cohabit together, and continuation of the formal legal relationship is unjustified. The court, as a court of equity, is required to also balance the circumstances and the background in which the party opposing the dissolution is placed. Headnote A. Demonetization policy. Excessive delegation of power to central government. Validity of Section 26(2). Subsection 2 of Section 26 of the RBI Act does not provide for excessive delegation inasmuch as there is an inbuilt safeguard that such a power has to be exercised on the recommendation of the Central Board. As such, subsection 2 of Section 26 of the RBI Act is not liable to be struck down on the said ground. Headnote B. Demonetization policy. Notification challenged. Test of proportionality. There is a reasonable nexus between the measure of demonetization with the purposes of addressing issues of fake currency banknotes, black money, drug trafficking, and terror financing. What alternate measure could have been undertaken with a lesser degree of limitation is very difficult to define. These are all the areas which are purely within the domain of the experts and beyond the arena of judicial review. Impugn notification dated 8 November 2016 satisfies the test of proportionality and, as such, cannot be struck down on the said ground. Headnote C. Demonetization policy. Judicial review. Notification challenged. Scope of interference will be narrower. Court to examine decision-making process on the limited grounds. Mere errors of judgment by the government seen in retrospect is not subject to judicial review. In such matters, legislative and quasi-legislative authorities are entitled to a free play, and unless the action suffers from patent illegality, manifest or palpable arbitrariness, the court should be slow in interfering with the same. Impugn notification dated 8 November 2016 does not suffer from any flaws in the decision-making process. Headnote D. Demonetization policy. Power of central government. Power available to the central government under subsection 2 of Section 26 of the RBI Act cannot be restricted to mean that it can be exercised only for one or some series of bank notes and not for all series of bank notes. Power can be exercised for all series of bank notes merely because on to earlier occasion, the demonetization exercise was by plenary legislation. It cannot be held that such a power would not be available to the central government under subsection 2 of Section 26 of the RBI Act. Headnote Demonetization Policy. Notification challenged. 52 days period provided for exchange of notes wide the impugned notification dated 8 November 2016 cannot be said to unreasonable. Headnote F Demonetization Policy. Power of RBI. Acceptance of demonetized notes after notification. RBI does not possess independent power under subsection 2 of Section 4 of the 2017 Act in isolation of the provisions of Sections 3 and 4, 1 thereof to accept the demonetized notes beyond the period specified in notifications issued under subsection 1 of Section 4 of the 2017 Act. Headnote A. Legislative Proceedings. Judicial Review. Article 212 cannot be interpreted as placing all procedural infringements beyond the pale of judicial review. Such an interpretation would completely disregard the importance of legislative processes in a constitutional democracy. Procedural infringements would vitiate the proceedings based on their purpose and the impact of their infringement on the democratic functioning of Parliament. Headnote B. Status quo ante. Reinstating the government head. Calling for floor test, exercise of discretion by governor not in accordance with law. Governor had no objective material on the basis of which he could doubt the confidence of the incumbent government. Status quo ante cannot be restored because Mr. Thackeray did not face the floor test and tendered his resignation. Headnote C. Judicial Review. Scope and power of Speaker to recognize whip and leader of House Legislature Party. Split within Shiv Sena, to resolutions appointing to different whips and to different leaders. Recognizing the action of a faction of the Shiv Sena without determining whether they represented the will decision of the political party, illegal. Speaker acted contrary to the provisions of the 10th Schedule, the 1986 rules, and the Act of 1956. Headnote D. Disqualification of MLAs. Cannot be adjudicated by writ court in the first instance. No extraordinary circumstance exists to exercise jurisdiction. Speaker must decide disqualification petitions within a reasonable period. Headnote E. Parallel proceedings. Power and jurisdiction of Election Commission of India, ECI. Allotment of symbol. Both factions claiming to be real Shiv Sena and allotment of bow and arrow symbol. Disqualification petitions of MLAs pending before Speaker. Proceedings before one constitutional authority cannot be halted in anticipation of the decision of another constitutional authority. Election Commission of India is not barred from adjudicating symbol dispute. ECI may apply a test that is best suited to the facts and circumstances of the case. Headnote F. Disqualification proceedings against MLAs. Power and jurisdiction of Speaker. Whether the issuance of a notice of intention to move a resolution for the removal of the Speaker restrains him from adjudicating disqualification petitions under the 10th Schedule of the Constitution. Correctness of the decision in Nabam Ribia referred to a larger bench of 7 judges. Headnote G. Proceedings of House. Validity. Disqualification petitions against MLAs. An MLA has the right to participate in the proceedings of the House regardless of the pendency of any petition for his disqualification. Validity of the proceedings of the House in the interregnum is not subject to the outcome of the disqualification petitions. Headnote H. Disqualification of MLAs. Impact of the removal of paragraph 3 of the 10th schedule. Defense of split is no longer available to members facing disqualification proceedings. Speaker would prima facie determine who the political party is for the purpose of adjudicating disqualification petitions under paragraph 2(1) of the 10th schedule, where two or more factions claim to be that political party. Headnote I. Appointment to the post of minister. Article 164, 1b, does not interdict the appointment of a member to the post of a minister if a petition for their disqualification under paragraph 2 of the 10th schedule is pending adjudication before the Speaker. Headnote A. Executive power of Lieutenant Governor. State list. Executive control over services of National Capital Territory of Delhi, NCTD. Whether the Government of National Capital Territory of Delhi, GNCTD, or Lieutenant Governor acting on behalf of the Union Government would have control over services held. Government National Capital Territory of Delhi has legislative and executive power over services, excluding public order, police, and land, under Entry 41 in List 2. Legislative power of the Union extends to all entries under the State Union and concurrent lists. Executive power of the Union, in the absence of a law upon it, relating to any subject in the State list, shall cover only matters relating to the three entries which are excluded from the legislative domain of NCTD. Executive power of the Lieutenant Governor acting on behalf of the Union Government shall extend only to matters related to the three entries mentioned in Article 239 AA, 3A subject to the limitations in Article 73. Legislative and executive power over services such as Indian administrative services or joint cadre services, which are relevant for the implementation of policies and vision of NCTD in terms of day-to-day administration of the region shall lie with NCTD. Definition of state under Section 358 of the General Clauses Act 1897 applies to the term state in Part 14 of the Constitution. Thus, Part 14 is applicable to Union territories. Exercise of rulemaking power under the proviso to Article 309 does not oust the legislative power of the appropriate authority to make laws over Entry 41 of the state list. Headnote B. The phrase insofar as any such matter is applicable to Union territories in Article 239 AA, 3, cannot be read to further exclude the legislative power of NCTD over entries in the state list or concurrent list, over and above those subjects which have been expressly excluded. Headnote C. The phrase subject to the provisions of this Constitution. In Article 239 AA, 3, the legislative power of NCTD is to be guided, and not just limited, by the broader principles and provisions of the Constitution. Legislative competence. Bovine sports. Jallikattu, Bullock cart race, and Kambala. All the three bovine sports, after amendment, assume different character in their performance and practice. Defects pointed out in the judgment of A. Nagaraja have been overcome by the State Amendment Act read with the rules made in that behalf. Tamil Nadu Amendment Act is not a piece of colorable legislation. It relates, in pith and substance, to Entry 17 of List 3 of 7 Schedule to the Constitution of India. It minimizes cruelty to animals in the concerned sports, and once the Amendment Act, along with their rules and notification, are implemented, the aforesaid sports would not come within the mischief remedied by Sections 3, 11, 1A, and M of the 1960 Act. Amendment having received presidential assent, no flaw in the state action. Tamil Nadu Amendment Act does not go contrary to the Articles 51-A, G, and 51A, H, and it does not violate the provisions of Articles 14 and 21 of the Constitution of India. All the three amendment acts held to be valid legislations. Headnote A. Dawoodi Bohra Community. Excommunication of community member. Legality. Test of constitutional morality. Protection under Article 26(b), granted by the decision in the case of Sardar Sayedna to the power to excommunicate a member of the Dawoodi Bohra community needs reconsideration by larger bench on the following points. I. Exercise of balancing the rights under Article 26(b) with other rights under Part 3 and in particular Article 21 was not undertaken by the Constitution Bench in the case of Sardar Sayedna. 2. Whether the protection can be given by Article 26(b) to the practice of excommunication is to be tested on the touchstone of the concept of constitutional morality as the said right is subject to morality. These questions are substantially in issue in review before the bench of 9 judges in Sabrimala temple case, and decision will have a direct impact on the questions which arise for determination in present writ petition. Writ petition tagged with review petition. Headnote B. Interpretation of constitutional provisions. Approach to be adopted. Case law discussed.